Hey everybody, and welcome back to our lecture series. And for today's lecture, we're going to continue with our discussion of civil rights cases of the 19th century, and we're going to move right into the second of the two cases, the two early cases that tested the 14th Amendment, the case of Crookshanks v. United States. But before we get into the Crookshanks case, I just like to do a customary recap and touch on what we discussed in our last lecture. So in our last lecture, we discussed how the United States, during the years immediately after the Civil War, in an effort to offer protections to African Americans against presidential assailments, primarily those launched by then sitting President Andrew Johnson, and also the rising violence, intimidation, and terror being launched by pro-secession, pro-Confederate recalcitrants. The Congress of the United States had passed the 14th Amendment, which granted one, citizenship, but also three very important protections to African Americans. Namely the Due Process Clause and the Equal Protection Clause. And in our last case, we also noted that the first time that the 14th Amendment was really tested at the federal level in a trial overseen by the Supreme Court, it was brought up by a group of European Americans who ultimately lost their case. Now, the second case, Crookshanks v. United States, involves one of the greatest, if not the single greatest, massacre of African Americans in United States history. This case, like the Slaughterhouse Case, originates in Louisiana, and in 1872, a dispute arose in Grant Parish over the results of a recent elections. The Republican Party, the local Republican Party, had claimed the offices of sheriff and judge. After the election, the previous holders, who were former Confederates and Democrats, refused to give up the office. They refused to give up their positions. Tensions mounted, and a pro-white supremacy mob was formed by members of the Knights of the White Camellia, a prominent, if not the most prominent at the time, Redeemer group in Louisiana. The Knights of the White Camellia rode through the parish, terrorizing African Americans, shooting and killing one man, Jesse McKinney, in front of his family. The local African Americans gathered at the courthouse, dug trenches, drilled with guns, and under the Republican sheriff, settled in for a siege. They were using the courthouse as a fort almost. Now, the two sides, the Redeemers and the African Americans, they exchanged intermittent fire for 2 weeks. On Easter of 1873, the conflict became tragic as members of the mob, armed with rifles, now introduced a cannon. They sent a delegation and demanded that the African Americans leave the courthouse. When the defenders refused, the mob opened fire on the courthouse with the cannon. They then sent in a captured African American with a torch attached to him to ignite the courthouse. Now, at the time, the courthouse had a thatched roof, and it was also really just blasted through. They had opened fire with the cannon on this sort of rural structure. The African Americans inside then poured out under a white flag of surrender, but they were shot down as they did so. And those who escaped initially, those who escaped the initial onslaught, were tracked down, lined up back to front, where members of the mob took sport, seeing just how many prisoners they could kill with one single shot. When it was all said and done, the corpses of the dead were dumped into the Red River. It is estimated that about 280 and more persons were killed in that single day. And this event is known as the Colfax Massacre. We discussed it when we looked at Reconstruction, but we didn't discuss the Crookshanks case when we discussed the Colfax Massacre during our lectures on Reconstruction. Now, federal authorities arrived the next day, and they arrested 98 of the attackers, who were then indicted under the Forces Act that we already looked at, the Forces Act of 1870, and they were charged with depriving African Americans of the right to assemble and of depriving them of life, and liberty without due process. Only 9 of the assailants stood trial, and of that 9, only 3 were convicted. The 3 men who were convicted filed an appeal with the United States Supreme Court. This appeal was heard in 1876. Morrison Waite wrote the court's unanimous opinion that overturned the 3 men's convictions. Now, Waite had succeeded Chase in 1873 and had no prior judicial experience. Chief Justice Waite drew on Miller's opinion in the Slaughterhouse Case. The Slaughterhouse Case had really been the only previous case that addressed the 14th Amendment's provisions, namely the 14th Amendment's, namely Miller's writings in his opinion that the 14th Amendment only protected people from state actions that deprived them of constitutional rights. Waite ignored the fact that the Forces Act were passed to counteract the lack of protection afforded to African American communities by Redeemer governments, and the fact that Redeemers like William Crookshanks targeted them disproportionately in hopes of depriving them of constitutional rights. Waite also wrote that it was no more the duty of the United States to step in and protect African Americans when the states failed to do so. Waite's decision fueled Redeemer violence and instilled a new confidence among Redeemer groups. Now, the court's ruling in the Crookshanks and Slaughterhouse cases marks no improvements in the plight of African Americans and served to enhance the pace of Jim Crow segregation. It served to increase the spread of the pace of Jim Crow segregation in those redeemed states. Now, though all the justices named to the court had been named by a Republican president since 1860, none of the justices of the Waite case really showed any concern for the fate of African Americans. Only John Marshall Harlan, who was appointed by President Hayes to replace Justice Davis, who resigned from the court, has been covered to go ahead and serve as a federal senator from Illinois, showed any inclination to support African American civil rights or civil rights on the whole. And Harlan would do so for the rest of the 19th century. Harlan was named after the former Chief Justice John Marshall, whom his father admired and whom Harlan himself grew to admire. Harlan came from a slave-owning family in Kentucky. He and his family had opposed the 13th Amendment, but he had also served in the United States Civil War. And Harlan would play a critical role in helping Hayes secure the Republican Party nomination in 1876. And you can largely look at Harlan's appointment as a return of a political favor, a political reward, if you will. But it should not be taken that Harlan was not an experienced lawyer or jurist. He was a highly respected and highly experienced lawyer at the time of his nomination and confirmation. Now, in 1874, the Democratic Party regained control of the House of Representatives, and the Republicans, before they gave up power, they passed the Civil Rights Act of 1875. Now, this act stated that all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations of such facilities as restaurants, theaters, hotels, and railroads. And this was based off of the 14th Amendment's provision to grant Congress the powers to support the amendment with appropriate legislation. Particularly, this piece of legislation was aimed at attempts by the state to deny equal protection under the law to any person, namely persons of African descent. It was clearly noted that this act was intended to prevent discrimination against African Americans in the increasingly volatile redeemed states. Now, 5 cases arose that eventually made their way to the Supreme Court, but 5 cases arose regarding federal enforcement of the Civil Rights Act of 1875, and they were decided in 1883. They are collectively known by the title the Civil Rights Cases, and these cases came from New York State, Tennessee State, Kansas, Missouri, and California, and they involved at their core the exclusion of African Americans from railroads, theaters, and restaurants. And it's important to note that Jim Crow did not only roost in southern states. Jim Crow, or American racial segregation, really grew socially after Reconstruction, or it spread across the United States in the 19th century like wildfire. Really, by this time, by 1877, 1876, and beyond, Jim Crow was really being viewed as a national institution. You can leave Charleston, South Carolina, and head to a city like Boston and find segregation practices in both cities very much the same. You can go to Chicago or Milwaukee, and you can find the exact same thing that's happening if you were in Memphis or Houston at the time. So Jim Crow very prevalent across the nation. It's not just confined to the former slave states. It's not confined to those redeemed states. And one of the cases in particular of 1883 was originated. It came from Topeka, Kansas, back in 1875. And this stemmed from the indictment of one Murray Stanley. Stanley was the proprietor of an inn, and he denied service to an African American man named Bird Gee. He denied him accommodations at the inn because of Gee's ethnicity. And this was a clear violation of the Civil Rights Act of 1875. The Supreme Court decided the case in October of 1883, and they decided it by a vote of 8-1. Justice Bradley wrote the deciding majority decision, which struck down the Civil Rights Act of 1875 as going above and beyond the powers of Congress and the Equal Protection Clause of the 14th Amendment. Bradley conceded that all the laws of the states require proprietors of public places to serve all unobjectionable persons in good faith. But he added that unless the laws themselves allow for discrimination on racial grounds, the acts of the individual proprietors could not be regulated by an act of Congress. Again, there's this sort of emphasis on providing sort of leeway, providing avenues in which discrimination can occur. Bradley relied on the court's previous ruling in the Slaughterhouse Case back in 1873, which severely restricted the court's enforcement power of the 14th Amendment. It restricted the enforcement of the 14th Amendment to the actions done by the states only. And his previous statement reinforced that, saying that whatever a private citizen does, an individual does, is no business of the Supreme Court, and Congress cannot legislate against it. Now, Murray Stanley, he said, acted alone in refusing service to Bird Gee. Not the state of Kansas. The state of Kansas hadn't done anything to abet Murray Stanley, so there's no federal oversight. There's no reason for the court to decide or place any restrictions on Murray Stanley. He stated that Murray Stanley was not accountable to any additional oversight. Bradley also included a very patronizing lecture that he lobbed at Gee and every other African American suffering under the emerging Jim Crow practices. Now, John Marshall Harlan was the lone dissenter, and he deplored what he called Bradley's narrow and artificial reliance on the state's action doctrine. In addition, Bradley's distinction of private and state enforced discrimination really didn't sit well with Harlan, and Harlan attacked them both. In his dissenting opinion, he stated that in all applicable situations of the 14th Amendment, railroads, inns, and all of the other public accommodations, proprietors and so forth are categorized as agents or instrumentalities of the state because they are charged they are charged and amenable in their duties and functions to state regulation, meaning that even if you wanted to say that Berge had his actions aren't really scrutinizable by the state, by owning a public place, by providing a public service, his actions are under the review of the state, and his actions reflect upon the state. Harlan continued by stating that the requirement that the requirement of the states for providing of service to all non-objectionable persons justified federal intervention. Harlan concluded by directly confronting Bradley's lob toward the African American community and countering it with a lecture of his own on the need to protect and defend civil liberties. And with that being said, we'll break here and we'll come back and we'll wrap up our overview of the civil rights cases of the 19th century.